Mr. J. Christopher, protect the righteous with wisdom and strength.
You mentioned mediation. Arbitration is something people have heard of before, court of law. So what are some of the forms and traditional ways to approach legal issues?
Well, those are the big three. I mean, you can either file a lawsuit, you can have arbitration, or you can have, and they're not mutually exclusive, mediation at least. I mean, a lot of times mediation, sometimes there'll be a mandatory mediation clause where you've got to mediate if a dispute arises, and then you either end up in arbitration or you end up in court. There'll be a specific arbitration provision normally.
We're gonna just dial this back a little bit because we need to park and unpack this for those who don't have JDs and don't have any concept of legal forms. What exactly is mediation and what exactly is arbitration, and how do the two differ from a court of law?
Well, I mean, they're streamlined. Arbitration in particular is a streamlined version of judicial proceeding. You're going to get an actual adjudication by a judge, maybe 3 judges, depending on how it's set up, and you're going to present your case in a similar way that you would present it in court, in trial, but just much more streamlined, a lot less formal. The rules of evidence aren't as powerful and as strong. It's cheaper, and one of the big benefits of arbitration, if done right, if the arbitration clause is crafted correctly, is that it's also confidential. So your company and your witnesses' names aren't splashed all over the Hollywood Reporter as soon as a lawsuit is filed. Well,
let me amplify that because I think that's important. You hit on some really key things. Arbitration is faster, it's cheaper, and oftentimes it's the more practical approach. However, you need to make sure in that arbitration clause of your contract, you have a confidentiality provision. Otherwise, as it relates to traditional court, that information or those pleadings, that the paperwork you submit is subject to public exposure, right?
Right.
Okay, so if you don't want to get out in the press about what you did with whom and how, then maybe go to arbitration. Let me ask you a question though. Can you actually still have that confidentiality, that privacy in a judicial proceeding in a court versus arbitration if you end up taking it straight to court?
Lawrence can answer this much better than I can, but you can get things filed under seal and everything like that, but those are pretty onerous things to get done. I mean, I think generally your presumption should be if it's going to be a lawsuit, it's going to be public.
Yeah, it's in very, very rare circumstances are you going to be able to go to a court of law, whether it's federal or state court, and not and be able to keep them out of the public eye. I mean, one of the fundamental things about our judicial system is that it's a public forum. And so Bobby mentioned the concept of filing something under seal, and that really pertains to a document or something that is highly confidential or maybe prejudicial to a party, where you have to go through a very specific process and asking the court for permission to file it under seal. That is also different from the notion that the actual hearings or the trial will be private. So if there's a trial, the public has a right to sit in the courtroom and see what happens, and we've seen that on our television screens year after year after year, right? So that's very rare. In an arbitration context, the public does not have a right to be in the room when the arbitration is going forward. And so I think what Bobby is referring to is private or confidential in a way. However, most standard arbitration provisions do not include a confidentiality provision that prevents the parties from talking in public about the fact that the arbitration is going on, what happens in the arbitration. So if you are interested in keeping what happens in the context of an arbitration private, then you need a specific provision in a contract that prevents either party from disclosing to the public either the fact that the arbitration is happening or what happens in the arbitration proceeding itself.